To Sushma Rahman, who is the Executive Director of the Carr Center for Human Rights, and she will be the moderator of our final panel. There you go.
Great. Thank you all. It's been a fascinating half day, and I'm drawn back to the words of Judge Prowse from this morning, where she said 20 years ago in Rome, it was a time of great unity, of conviction, and of hope. And as she looked forward to the next 20 to 50 years, she talked about first the need for universal jurisdiction for the Rome Statute, and then finally no need even for an international court. So this panel really draws on a diverse range of experts who are going to share their perspectives and also look ahead to the future. We're going to start with Luis Moreno Ocampo, followed by Alpha Sese, and then finally Martha Minow. I could spend the entire hour reading out their bios because they're all very accomplished in their own right, but the bios are in your packets. So I'm going to turn it over to Luis now to get us started for a brief presentation, and then I'll turn it over to Alpha.
Yeah, commenting on what we heard today, on following your line on, in fact, in my office, some Australian lady was saying, oh, in 40 years it will be a museum. People will come to the Hague and see how people in the past were committing crime, now it's over. So that was great. But for me, something connected with Kipro is about institutions. Maybe there were more enthusiastic people, less people vocal now, but as it's still working, that is for me the concept of institutions. They have a budget, they have a building, people working, it's a job. It's not that they are volunteers, it's not that they are NGOs, they are working, and that's their job. So, and that for me is the difference between having an SEC and not having an SEC. And whatever we say, so we heard here today how SEC is influential in Colombia, working out in Venezuela. So the first point is about, I'm trying to see how to explain in the Kennedy School the new role of institutions, not international institutions that just make agreement between states, independent institutions who can implement things. That is for me the new of the SEC, and should be exported, should be a new model, different model, but we should stick on that, because that's a different use word. So the first point was, for me, was about institutions. But the second point is about leadership. Because in both sides, in committing the crimes and in stopping the crimes, in both sides. Because I like to think in the I think Doc told me that, in the learning curve of the criminals. Because what happened in Venezuela is different than Darfur, for instance. There is not a massive attack. There is a subtle attack. 12,000 people in jail, and the judges were not judges. In the OAS, in the hearings of the OAS at Washington, the judge who put in jail Lopez, the main opposition leader, said she was refusing to sign the arrest order. But there came 18 security forces, came to her office, and told her, or you sign the arrest warrant, or we'll arrest you, torture you, and rape you, as we did with other judges. That's what she said. And then she signed, and 50 days later she escaped. So, it's not the squads. The 12,000 persons arrested were arrested following orders of judges who are working in this way. So that's why Human Rights Watch, for instance, is not gathering that. So I believe what we need, and I don't know how many lawyers are here, we need to refine, understand how the new crimes are committed. It's not just so brutal, open attacks, raping entire village. No, they're using judges to arrest people, not the squads. So that's Maduro is a very smart leader. So he's allegedly committing crimes, but he's very smart. He divides the opposition, and he's one of the few kinds because a special ambassador at The Hague. The ambassador at The Hague is a foreign prosecutor, the sister of the vice president, and her job is to work on the SEC. So that is what he's doing. That's my first point. leadership matters. Institution matters, but leadership also matters. Maduro matters as a leader, but that's why the Almagro formula matters. Something Almagro did not explain well, I think, is I am Argentinian. In my country, in 1980, the Inter-American Commission of Human Rights stopped the dictatorship. Now, when the Inter-American Commission is working and passing information to the other organs of OAS, OAS was not able to vote against Maduro. Why? OAS needs 18 votes, and Maduro, using the oil, convinced the Caribbean island to work for him. So that's why the OAS was not working with efficiency with Maduro. And that's why the Almagro formula was they get to escape. Okay, to adopt a decision in the OAS, you need 18 votes. To go to send a case to ICC, you need 1 vote. And that was the plan. The plan was, okay, indeed, we organize hearings at the OAS, we listen, we have an expert report analyzing the crimes, and then your job will be to convince one state to refer the situation. That's it. He got 8 now. And that is, in terms of institutions, the new thing. It's not just about individual institutions, it's the connection between them. And that is, for me, what the CAT Center has to learn. How we work with institutions, and how we connect institutions. And my last point is about Africa. Because I mentioned this story on the Tanzania and the African Union. Basically, I believe in Africa what we need is not more courts. We need African leadership to protect the African people. And to do that, we have to give them, the African leaders, more space. I believe this OAS initiative could be replicated in African Union. But I don't know, Kim is against my idea, but maybe we should go forward and, for instance, give the regional organizations the power to refer the situation to ICC and to stop the situation to ICC. So, Security Council has Article 15 authority to stop the cases, and Security Council can send cases to the ICC. No OAS, no African Union. Maybe it's time, but then Security Council does not care about Venezuela and does not care about Burundi. So maybe it's time to give more space to the regional organizations, proposing an amendment, giving more space and giving the African Union the chance to give an Article 16 to suspend the investigation against Bashir. But then will be, it needs to be a blanket Article 16, because basically what happens in Security Council is Security Council has no authority, they can do nothing, they cannot put any pressure on Bashir now. Indeed, if they have Article 15 for it's 1 year, Article 16 allows Security Council to suspend an investigation for 1 year. You give African Union, imagine African Union with the power. They give one Article 16 to Bashir, to Burundi, to 3 or 4, because you have many candidates. Okay, but then you impose conditions to them, because next year should be renewal. And at least it will be a political debate in the proper space, in the political leadership, not in the court. Because it is not a court problem, it's a political problem. And that's my feeling is we need to learn to understand what is something for the courts, like basically it's about individual responsibilities. And what about political debates, how to manage a country. That's why for me what President Santos was saying about the ICC role is unique. You see also a leader who understood the role of ICC, even sometimes he was afraid of himself, but he managed to use ICC to achieve an incredible peace process. And, that's my last point, I believe we need African Union, one idea, Alpha will comment on that, but I think we need to think how in Venezuela we can use something that Marta told me. Marta told me 8 years ago about the shadow of the court. It's not because the story is, Manu can explain that, there are many divorce cases that they never go to the judge. The lawyers discuss the divorce in the shadow of the court. And that's the concept. So now they have a referral on the SEC. We need to think in a soft landing for Venezuela case. And the best soft landing will be Maduro himself. Maduro should, complementarity, as Kim Prost explained today, complementarity is the concept to prevent ICC intervention. Colombia has is 12 years under criminal examination, never open a case, because they are doing a lot of cases themselves. They exclude everyone. And in fact, I remember with Uribe, when I told Uribe, Mr. Uribe, you're not doing false positive, the army crimes, he started to do it. Today there are 200. So complementarity is the way to do it. Maduro could investigate the generals, could investigate whoever committed crimes. Of course, it will be complicated for him, but it's a soft landing. And that will be the way to stop the crime. That was the main point of President Santos today. And we need an opposition able to debate how to manage the future. That's what we are missing. It's not the idea that ICC will solve the problem in Venezuela. It's wrong. It's a wishful thinking. Nothing which even dream with Maduro in jail in The Hague will be replaced by someone worse than him if you can arrest him. So I don't think the issue is to put him in jail. The issue is how you use, as President Santos said, the phantom of the possibility. The Damocles sword is strong when it's pending. When foul, kill one, but that's it. So my feeling is it's a moment for the Carr Center to debate how to help the Venezuelans, how can help to play together, how can help them to move in a soft landing, because the crash landing will be bad for everyone. How we make real the shadow of the ICC. That I think this conference is about, how we can transform our ideas, our expertise in something specific, a policy that helps the Venezuelans to move forward, stop the crimes, and move ahead without crashing the men. Thank you very much.
Thank
You.
Thank you very much. First, I'd like to say that the former prosecutor's constant nod in my direction when referencing the African Union is not to say that I work for or speak for the African Union. I just want to make that clarification. It's because I've been working on issues around the ICC's relationship with the African Union for some time, and they're attempting to throw some light on that, specifically trying to look forward. So, like everyone here, I'd like to thank the organizers of this event for the opportunity to share my thoughts. As you will see on the program, my name is Alpha Sisi. I work for Open Society Justice Initiative, and I'm here as a visiting human rights fellow in the law school. But the views expressed here are mine. So I'd just like to make that clarification as well. So, first, I'd like to say that the relationship between the ICC and the African Union is well documented, and now you can actually draw a difference between the relationship, so you can draw a difference between the relationship that the ICC has had with the African Union and that which it has had with African states, as well as you can say with Africa as a continent. And we do note that over the years, this relationship has deteriorated, and which is not the subject of this panel, and currently an excellent job, trying to throw light on some of those issues. But it is my view that when we have these discussions, we certainly will note the challenges that have existed between the court and the African Union. Not because we really want to rehash the past, but because we want to use those lessons to shape the engagement with the African Union or with the continent going forward. And by way of background, we should note, and the learned judge made reference to the important role that African states played in Rome when the statute was adopted, and actually it is on record that the first country to ratify the Rome Statute was an African state, Senegal. And between 2004 to 2007, universal African ratification of the Rome Statute was actually part of the AU strategic plan. And there was good relationship with engagement with former prosecutor Ocampo, the president of the court, etc. But things began to deteriorate, after 2008, and from 2009 onwards, as Karen mentioned, we saw that the African Union started raising concerns, adopting decisions at almost every summit. of the union, in which it called for non-cooperation in almost all of these decisions. The actions and decisions of the AU, whilst I state that they do not represent the positions of each individual member state towards the ICC, they're still important because they provide an insight into the evolution of the relationship with the court and the major sticking points and where there may be opportunities to address these challenges. It is also important to note that during these challenging years, the ICC as an institution continued to have cooperative relationship with, on some issues, I would say, with some African states, and the court also has continued to receive substantial support from victims and African civil society. So what are the main concerns, and how do they provide an opportunity for us to engage as we look forward? These can be divided into two, and these are from the points of view of the African Union. And so, like I said again, I do not speak for the AU, but these perspectives are just based on my engagement with various actors within the institution and with other institutions on the continent. From a legal standpoint, from the perspective of the AU or actors within the AU, there remains a lack of clarity on some legal issues, specifically articles in the Rome Statute, and the AU and some states points at, say for them, there's a lack of clarity on specifically Article 98 as it relates to Article 27 of the statute. And for some, there have also been concerns about the lack of clarity on the meaning of complementarity within the framework of the Rome Statute. And so these are issues that we really cannot run away from. But from the political standpoint, the AU has had its own complaints, saying, the court continues to focus on Africa, despite the fact that we all know how all of these cases came before the courts. And there have also been concerns about how the UN Security Council handles referrals. And this comment was made earlier on about the important role that France and other countries are playing within the US Security Council about the use of veto when it comes to atrocity crimes. And when we discuss the relationship going forward, noting some of the important concerns that the African Union has, one thing that the African Union has tried to put on the table is a reform or a review of this particular process. The AU also wants a discussion on how the veto is used within the Security Council, and whether it's possible to not use that when it comes to atrocity crimes, or their proposal that if you can't find an agreement within the UN Security Council, then move discussions on atrocity crimes to a democratic platform within the General Assembly where there can be votes. So whilst we exchange views on how disruptive or otherwise the AU's approaches over the years have been, we'll look at the recent responses to ICC issues and how they provide opportunities for probably like a new paradigm shift in the court's engagement with the continent. At the January 2017 summit, in one of the very many decisions that the African Union has had to adopt as it relating to the ICC, the AU adopted what it called a withdrawal strategy. This strategy was only a withdrawal strategy in name, actually, but when you read the actual strategy, you might make other conclusions. But in this strategy, there was a specific decision to pursue legal means to resolve some of these issues. Talking about seeking an advisory opinion on some of these sticking points. And also note that in the 2017 decision, for the very first time, certain states officially registered their reservations to the decision of the African Union as it relates to the ICC. And also, for the first time in very many years, in 2017 decision, there was really no mention of non-cooperation or request for a deferral of the Darfur situation. So, I think that is that's progress. And also, we saw that in in the Kenyan cases on the issue of Rule 68, the AU, instead of writing a letter to the ICC, the president of the ICC had done previously, decided to make a submission before the court. And recently, on the same Bashir issue, when the appeals chamber invited submissions from various regional bodies, the AU was actually one of two bodies to submit to make a submission. So this new way of engagement with the ICC, which is really through legal submissions, could represent a paradigm shift in the AU's engagement with the courts. And certainly, in different form, writing letters, engaging the legal process is a better approach. And another possible way of engagement between the ICC and the AU as we look into the future is to really discuss the possibility of the very brilliant work that the OAS have done as it relates to Venezuela. And the AU at its level continues to set up high-level panels for various situations, and the Constitutive Act of the AU itself talks about the AU getting involved in particular situations when atrocity crimes have been committed without the consent of that particular state. So this is also a brilliant example that is really worth discussing. There are also other institutions. I think there's an obsession with engagement in Addis Ababa. There are other institutions within the African Union that the ICC could really seek to have engagement with, the Peace and Security Council, the African Commission on Human and People's Rights, which has actually made statements and expressed support for the ICC's involvement in certain situations. So, as we look forward to, continued engagement with the African continent, I think that is something that we should also really consider, the engagement with other institutions besides Addis. I'll keep a few points and just get to my closing points because I'm out of time. Just a few final thoughts on the court's engagement with the African continent, as we look forward. It is my view that there really ought to be a long-term approach to relationship building with Africa and the AU. This could consider, what are short-term, long-term, and medium-term engagements. And as I've said, probably consider keeping this at a particular level and engaging with other institutions within the AU architecture, the Peace and Security Council, the EU Commission on International Law, the regional economic bodies, etc. And then I think it is also important that sometimes instead of really focusing on the issues that we disagree on, it's really important to look at the issues that the ICC and the African Union agree on, or issues on which they can find themselves on the same page. And then, we state these, then we build on the successes that we find in those. And then the Peace and Security Council of the AU is a major entry point. Does it need to start at the highest level, or should consider this building relationship with permanent representatives and looking at norm formulation within the AU. The various instruments that touch on rule of law, human rights, democracy, etc., etc. And then, really the elephant in the room, which is the Malabo Protocol. As effective as it is, I think we ought to consider that, if the train has left the station, if the statute, the protocol has been adopted, if it happens at some point, we should have discussions now as to, what the possible engagement will be. So I'll close at that point because I'm out of time, and then, we look forward to sharing additional thoughts during question time. Thank you.
Someone once said that a civilization advances when what was once thought to be a misfortune, it becomes understood to be an injustice. That is the project of the ICC, is to take horrors and say this is not just a misfortune, this is an injustice. I want to say my thanks to the organizers and my admiration for the panelists. I came late. And so I really have no standing to say anything. But it won't stop me. It reminds me of a conference where the end of a very, very long conference, very last panel, the very last person on the last panel said, everything that needs to be said has been said, but not everyone who needs to say it has said it. So I just have a few reflections. I did have the chance to talk with some people who were here earlier, but excuse my remarks if they are not so relevant. I do very much like Luis's comments about institution building and leadership. And I do think that who the leaders are when institutions are founded makes a difference. It sets a tone, it sets aspirations and large shoes. So my hat off to Luis. I also want to say that Catherine's empirical work is absolutely critical. One of the differences between law and medicine is that medicine actually studies itself, and law does not. Medicine actually assesses, is there achievement, is there progress? In 1900, if you went to a hospital, your chances of dying were greater than if you stayed out of the hospital. That's not the case now. Why? Because they moved to evidence-based practices. We need to do that in law. And so I think along with institution building, we really need to underscore the study of the institutions. And that is a key role, I think, for the Carr Center. One of my own projects in recent years has been to look at child soldiers. And here we just have to understand the ICC as an absolutely pivotal institution in making real an international law aspiration that the recruitment and use of child soldiers is a crime. You know, we can say that, but until someone is actually charged with a crime and there's a trial about it, it's just an idea. And now it's not just an idea. And the Lubanga trial, I think, is a landmark on something that people have been talking about for a long, long time. In my own work, I think that the punishment of adults for recruiting and using minors in crimes against humanity and atrocities is only one of the contributions of the ICC. I think another is not pursuing minors. That's also an accomplishment, which is, again, much discussed in international law. There's ambiguity, the conflict or distance between the Convention on Rights of the Child, that really say one should not punish children or people under the age of 18 or 20, and then actually international criminal law is not so clear, but there have been prosecutorial decisions and there have been practices that say, no, this is not the most serious crimes, and that's also an accomplishment. I think the United States could learn a lot from looking at the treatment of child soldiers that has happened in the shadow of the ICC. The recognition that there really are ways to put the blame on adults and to work on reintegrating the former child soldiers. We could learn a lot from that with regard to juvenile justice and criminal justice in the United States. I want to say something about complementarity. I do think that the innovation that the ICC has on complementarity is perhaps its biggest contribution conceptually to law itself and to institution building. Working it out is really hard, but how brilliant to take the limitation of capacity and turn it into a virtue. And to say, actually, we could never imagine it being possible or good for an international institution to take over the Justice Project. Instead, the international institution should be engaged in a partnership. And complementarity actually has both the negative and the positive faces, that the court and the prosecutor won't act if there is a prosecution or activity in the nation state itself. I think it would be good to think more about complementarity and the regional bodies like the AU. I mean, I think that is something that wasn't really anticipated in quite the adequate way when the Rome Statute was built. And that's the negative that's pulled off, and there's a little bit of a threat, a little bit of a pressure, but also there's positive complementarity, where the court itself has invested in capacity building and strengthening justice systems around the world. My own work, I'm arguing that actually there should be complementarity recognition of non-prosecutions, of truth commissions, if they meet certain requirements. If they meet the requirements of actually naming names, having accountability, being serious, but I think that it's one way to deal with very fair criticisms of the elevation of only one form of justice as the only way to manifest justice. There are other forms of justice. And transitional justice mechanisms and traditional justice mechanisms are worth thinking about. And if the ICC really wants to make complementarity something that's meaningful around the world, I think it means taking that subject on. This limited capacity of the ICC is a definition. That is by definition. It is limited. I understand that some of today's discussion has addressed the question about whether there's enough going on, even within those limitations. You know, I think there's a choice about whether to be modest or ambitious in the institution. To take on cases only where the evidence is there, and there can be a successful prosecution and conviction and survival in the appeals process, or to test the limits. I think that the arguments are both ways, but I actually think that some degree of ambition is a good idea, even if there are some rejections, some overturning of cases on appeal. It's about pushing the boundaries about the content of the law and also, again, the shadow of the law. I understand, of course, there are failures of the outside participating actors. We can all rail against the lack of resources and the lack of cooperation and the lack of participation. And there are steps that maybe can be taken. But there are also ways in which the institution itself, by being ambitious, can shame others. And that's an important role to play. The dichotomies of past and future, law and politics, misfortune and injustice, these are the frames that I think about when I think about the ICC. Of course, as a court, it looks at the past, but it's about the future. It's about the future in terms of deterring misconduct and also building capacity for justice to be done around the world. It's about law, but also it's about politics. It's about creating a context in which political discussions will be different because of the possibility of law taking a stance. Sometimes that means an uncomfortable role for the legal actors in the court. Do they participate in promoting discussions? What's the relationship between justice and peace? These are very uncomfortable questions for lawyers. Louisa often said to me, I'm just a prosecutor. And I'll lick my hat now. So how can lawyers actually encourage the best uses, the fullest uses of a legal institution, which frankly are way, way, way beyond the law? I think that's a big, big question. And then finally, again, misfortune to injustice. What does it take? It takes institution building, it takes leadership, it takes norm building, it takes empirical study, and it takes meetings like this one. Thank you.
Thank you all so much. I think the richness of today's discussions has been that we could take any one panel and convert it into a day-long conversation. So thank you. I'm curious your thoughts on, as we look to the future, the role of seeking justice for victims, like we heard in the case of Venezuela, which is so grave and severe, and as well as looking at deterrence. And it's so much harder in a way to focus on deterrence. And Beth Simmons this morning talked a bit about evidence and the role of evidence in showing that there's been a reduction in state attacks with no effect on rebels. And I'm curious about your thoughts, any of you really, on the issue of deterrence, because if we want, as Judge Proust envisioned, a future with no need for an ICC, how do we get to both getting justice for past crimes and then also deterring future actions?
Most important deterrent impact is the political leadership. You heard Sandra today, that would he use the ICC to put deterrence on the FARC and on his own army. Who can do that? No one else. The rest of the country can do that. And that is, for me, I was a prosecutor, now I'm out. Now I can talk openly about the politicians.
Yes.
And today we have an incredible benefit to have two leaders, the president and the president of the OAS, saying openly what they were thinking. And it's different than what you think. And for me, some of them were shocking, but fine. So they are different people. But and that's why for me, both of them are an example how they learn to use the law to manage conflict and to deter crimes. Because that for me, my feeling is, I agree with you, we need data, we need research, but the problem is you are so specialized that you just see the details. In my job, everything was together. The investigation, the political support, the communication, the NGOs, all this, the selection of the charges, all this go together. So I have to mix. It's like when you are a cook, you have to combine the elements. And here we are the potato. 5 people talk about potato. We don't talk about onions. Not onions are not our business. Come on, guys. How can you cook if you are not combining the elements? And that is, okay, that's my new metaphor. I don't know how.
iPhone metaphor did not work for you. The iPhone.
Oh, it was great, the iPhone. The iPhone.
Sorry for the distraction. No, but just like an
Because
offside.
I was challenging the I think an iPhone, and I said, also, it's an iPhone bad design. I said, no, it's a good design iPhone, the problem is the Wi-Fi. So if you are in some place, in Sweden you have a great Wi-Fi, in Colombia you have good Wi-Fi, in other countries no Wi-Fi, so it's a Wi-Fi problem. So no, because the iPhone just has to see and create a system. Okay. You see? Okay. I hate my metaphor of the onion potato. Very, you can remember. Yeah. The difference about combining the element. We need political leadership. It's not, and then you have to focus. Yes, there are social demands. Yes, they are cool, but then the main role is the political leaders. If the U.S. political leaders keep insisting the war on terror, that's a problem for the Justice Initiative. The war on terror, I like Martha Mino say a few months ago in a conference about the war on terror, she said the biggest casualty, the little casualty are our values. That's what she said, and she got it right. So that's the point, the potatoes and the onions. If we talk about the ICC alone, without mentioning the war on terror, we are missing the food. Both ideas are irrelevant, and then we have to integrate them and understand. If we are letting this idea of the war on terror keeping moving ahead and expanding around the world, yes, there will be no change.
I have just one story to tell, which is in the early days of the ICC, I talked to Samantha Power about how I thought it was a lot of money that wasn't actually having much of an effect. And then she told me about actually, going to Congo and learning that some people were wearing masks so that their names wouldn't be known. And they were fearful about actually being held to account. That was, for me, oh my gosh, there's deterrence. So, amazing.
I mean, just some thoughts from my end. I think we talk about the ICC facing a perception problem in Africa or in very many African countries, and it's very quick for people to point at Kenya as the ICC's disaster. But I think, and this is my view, and speaking with some other people on the ground, as much as you can say that the Kenyan cases collapsed, I think there is really a case to make that the ICC's intervention into Kenya, has had a deterrent effect when you look at the other election cycles in the country. And I think that is something that it was really good to look at. Another situation that I can look at, not an ICC situation country, is my country, it's Sierra Leone, where atrocity crimes were committed, special courts and truth commission, and the impact that these institutions had on the ground was immense, and to this day, as much as you can question the court's legacy in other ways, or whether people still remember the TRC, there are really tangible impacts on the ground, and as distant as the ICC might be from Sierra Leone as a country, because of what happened in Kenya and what happened in Cote d'Ivoire, Sierra Leone has had 2 election cycles, ahead of election day, massive tensions, but you actually hear the 2 leading candidates threaten each other with the ICC and making reference to Kenya and Cote d'Ivoire. So that's it.
So let's open it up for a couple of questions. I know we're almost out of time, but if you could go to the mic, introduce yourself, and a brief one-sentence question.
You straight there now. No one will. 2 lines, 3 lines, come on.
If you could come to the mic, that would be terrific.
I wanted to make a comment, and I can't leave without it, so please allow me to say it, because if you are in a situation and you see that one person is dying, and there is a second person dying, and there is a third person dying, that's a statistic. And then you can start determining. So paying attention to the minutia and what is going on around matters more than anything, because that's prevention. When you start paying attention and give people the opportunity to communicate and have someone that they can go to, then there is a report. 120 people a month or 2 months, whatever, is a lot. And I think it takes, if the ICC is not working, then something has to be created.
What?
Because it's too, no, in a way that is going to be.
Could you phrase it as a question, just because we're almost out of
Oh,
time?
impact, okay, so what does it take to,
Venezuela. You're talking about Venezuela.
around all the crises that are mentioned in your experience, what would be a recommendation at this point that we could sort of frame a vision that is going to help people at least think positive?
Tomorrow I'm going to Washington just because our Fury victims invite all with me to the ceremony. I'm the only one they invite because they appreciate what we did for them. So in many cases we're working. Venezuela will come. But it's a lot of things to do for people like you. You can follow the minutiae and send information to SEC. But also something was commenting even by Beth today, the communication of the court activities. The court cannot manage the communication. Should be others manage the communication. In Argentina, I think, I don't know if I say it today, there were the junta trial and there were 400 films in the last 35 years. 2 of them received an Oscar. So the judges did nothing. Similar in Nuremberg. In Nuremberg, the New York Times used for the first time, used the word Holocaust in 1958, after the Anna Frank diary movie, and was after the Spencer Tracy movie on Nuremberg that became Holocaust with capital H. So movies, songs, we need John Lennon imagine, a new John Lennon imagining new things, putting imagination in reality. So it's not about waiting something for the court. We should take action. That is my advice. Use your energy. There are so many things to do. Don't wait for Kim Prost. We help her, not wait for her.
I have a question. Stan again from Physicians for Human Rights. I'm curious, a number of you have talked about capacity building and the need for that, especially in terms of positive complementarity and domestic prosecutions, and in the larger context that you mentioned about people don't, and it came up in the earlier panel, people, public, victims, jurists, etc., don't really understand still, even in the countries where the situations are ICC referred, etc., what is the expectation to have. And I'm curious, what, if you could identify a little more deeply what kinds of capacity building work, and also how you feel, because Martha, you mentioned these compromises and the discomfort with, like, I'm about to go to Iraq next week, we're doing capacity building for documentation and prosecutions, and of course we know that the judicial framework and the, for all of it is pretty not something one would be happy with, and it's certainly not in compliance with anything in the Rome Statute, well, pretty much. So how would you advise the capacity builders? What are the priorities and what are the compromises that are okay or not?
I think the main capability would be presidents, leaders, who need to train them to understand, to mix potatoes and onions. They cannot choose one. I think Maduro crimes are much sophisticated, but discussion on peace and justice is all the same. 15 years with the same discussion. We're not evolving. What happened with us? So, in matter of training, I build political leadership. Because you're going to Syria, it's great. It's great to do this collecting evidence. However, we know U.S. was refusing to refer the situation in Syria because the U.S. is involved in Syria, and U.S. does not like investigation in Syria. Then, 1 year later, U.S. stopped Switzerland, was pushing for a referral. U.S. stopped Switzerland not to do it. They stopped Switzerland. 1 year later, U.S. supported the referral, forcing Russia to veto. It was just to expose Russia. That's it. That's the game. So there are many political games. So that's why, for me, we need to understand the political games, and more. We're focusing off in what happened with the victims. I think we should do a summation of actions in the Security Council. You have to do like a collection of DNA of the politicians in the Security Council. So we have to follow them. That is the target. It's not because the demand of justice are there. The delivery is missing. The court is there, up and running. They will do a job. But the missing part is the political leadership. U.S. is not just Trump. At least Trump was in reaction. Obama was, as I said before, using the warrant on the SEC to make a different deal with Bashir. It's legal. He had the right to do it, but nothing happened to the full victims. And now in Europe, Sweden became right-wing. So we have a problem in the world, and that is connected with the management of the international terrorists, because the reason to do crimes against humanity is because it's never a national crime, crossing border. And what happened in Iraq is crossing border to Europe, and what happened in Venezuela is crossing border to South America. So, and that's what to stop it. And it's not, and that's why for me, this idea to understand the impact of the war on terror. That's why this morning I quote Stanley McChrystal when he said, the insurgency math. The counterinsurgency is basically promoting more terrorism. McChrystal said there are 10 terrorists in Afghanistan, we killed 8. Sorry, we killed 2. How many remain? 20. So we don't, that is a big picture problem, not the detail in court. The judges will review the process. The judges will keep adjusting. Yes, I'm sorry. I'm enthusiastic. So my recommendation is you do a job, it's fine. You do what you can, but try to think how to do a forensic activity in the cabinet, in the presidents, in the security matter.
So,
Yeah, I mean, just very short from me. I mean, can't get into the specifics of, I mean, not enough time what exactly we need to do like in Iraq. I'll just say, one thing. When it comes to building capacity, I think we have to first acknowledge that each situation is different. And having a one-size-fits-all approach to every situation to just cause more problems. So I think one thing that I always recommend is a thorough understanding of the local context is always very important when you get into a particular situation that will really guide you.
so maybe a closing thought on building capacity and leadership.
Well, I should disclose that I was one of the founding board members of the Iranian Documentation Human Rights Center, which is, if ever there was a quixotic effort, here it is. We're going to build a documentation center, imagining somewhere, someday, there will be trials. But that's how I think about the capacity building. I think you build capacity on the ground right now to collect evidence, to prepare people for giving testimony, so it's there for someday, somewhere, somehow, there'll be a place that it can be used. And, if you build it, it will come.
Do you want to say any closing words?
No, I want to say thank you very much to every single speaker and participant, to Judge Prost, to Martha Minna, who's been our counsel, which helped us say, and to all the participants, to Carr Center staff who worked so hard, and Sushma, and to John, and to Sarah, and to all of you for excellent questions and for stamina for our long day. Thanks very much.